with its laws, its processes, and its procedures, the existence of the courts-martial cannot be questioned. Let me conclude on this note. Courts-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the Army Courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system, and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts-martial of the cross-appellant stroke respondent and civilians of equivalence under section 1191G, read 1171G, is in breach of articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the general court-martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings of movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant Ogwang Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts-martial. In this regard, an amendment of the Uganda People's Defence Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts-martial. The other question Ogwang raises is a requirement to delimit what a service offence is during peacetime. I propose that a soldier who commits a civilian offence when he is off post and away without pass leave or a wall should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds. The main appeal succeeds in part. I make no order as to costs.
I call upon Lady Justice Elizabeth Musoka to deliver her judgment. You will please bear with her. I think she's got a little cold, so she needs your patience and understanding, my lord.
I hope you hear me. My voice is a bit coarse, but this is a summary of my judgment. The judgment will be provided as the leader of this panel, the head of the panel, will advise. The appeal and cross appeal in this case, again, is the decision dated 1st July 2021, rendered by the Constitutional Court. The quorum of Kakuru, Obura, Madrama, Musota, and Kasule acting judges of the Constitutional Court. That is Michael Kabaziguruka, Honorable, versus Attorney General. The Attorney General is the appellant, stroke cross respondent, and Honorable Kabaziguruka is the respondent cross appellant, stroke cross appellant. The particulars relating to the declarations and orders sought in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft the judgment of the judgment of Mugenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross-appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial under Articles 28(1) and 44C. And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which conferred jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, insofar as the punishments prescribed for Part 6 offenses are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 of and Section 179, which confers jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offences under the Penal Code Act and other enactments. The jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions. The only punishments that can be imposed by the military courts under Article 2010. But they include serious punishments like imprisonment and death sentence, as I said. Thirdly, in relation to Section 2 and Section 1191G, which confer jurisdiction on the General Court Martial and other military courts to try non-members of the UPDF who are alleged to have aided and abetted members of the UPDF in commission of Part 6 offences. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that the category of persons covered by this jurisdiction are not members of the UPDF, in respect of whom Article 210B was intended to cover. In addition, as with the first two categories, the jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF because the prescribed punishments for Part 6 offences, which include the imprisonment and death, are more severe than the disciplinary sanctions which can be meted by the military courts under Article 2010B. Fourthly, with respect to Section 1191H, which grants jurisdiction to the General Court Martial and other military courts to try non-members of the UPDF who are found in possession of proscribed military equipment, this jurisdiction also goes beyond the sphere of discipline and removal of the UPDF, members of the UPDF, for three reasons. First, the persons affected are not members of the UPDF who fall within the jurisdiction of the military courts. Secondly, Section 1191H appears to be a penal provision, but it does not prescribe a punishment. And thirdly, the punishment for analogous offences under other laws include terms of imprisonment, which fall outside the nature of punishments that can be imposed by the military courts under Article 210B. Which are limited to disciplinary sanctions. In light of these observations, I find that therefore, to the extent explained, unconstitutional and null and void. For the fourth category, which is provided for under Section 1191H of the UPDF Act, I find that it does not fall under the sphere of discipline of the UPDF, as it is neither concerned with members of the UPDF nor with disciplinary sanctions that can be given to members of the UPDF for engaging in unacceptable conduct. For analysis, the analysis of the above second question will be found on page 10 to 15 of my judgment. The third question, it's with respect to the question of whether the General Court Martial is a subordinate court. I note that Parliament is required to enact legislation under Article 129(1) D for the